Well, now at 4:30 today, the verdict is in for the truck driver who caused that deadly I-70 bus crash in Licking County. So here it is, just hours ago. A judge found Jacob McDonald guilty of 6 counts of vehicular homicide. But these are misdemeanors because the judge said there was no evidence of reckless driving, which means McDonald was found not guilty on the 26 felony counts. We spoke with his defense attorney moments after that verdict came out.
He read the definitions. I believe the definition of negligence fit this. And there's a reason we tried this case to the bench. The difference between recklessness and negligence, there's a finite line within the law as applicable to the facts. So Judge Bransful's been a judge for 20 plus years. He was a defense attorney for 10 years prior to that. He's a super smart guy and a fair judge. So we tried it to the bench because we wanted him to make that interpretation.
Now, a sentencing date has not been set, but this verdict has a lot of mixed reaction today. Joining me now is former longtime Franklin County Prosecutor Ron O'Brien to help explain really what we heard from that courtroom. So, Ron, it is certainly good to see you. And the judge said the state really failed to establish beyond a reasonable doubt the act of recklessness. Can you explain the difference between recklessness and negligence?
There is a statutory definition of the 4 mental states: purposely, knowingly, recklessly, and negligently. And recklessly is defined in the statute as a heedless indifference to a known risk that causes a certain result. And that sounds highly technical, but essentially it means someone's acting very, very carelessly, whereas the lower standard of negligently is acting with what the statute says is a substantial lapse from due care. It's higher than ordinary negligence, but lower than recklessness. And it's a fine line. And in all the criminal statutes, the mental state's very important on what the state can prove or what the state fails to prove. And it sounds like here what the judge found was that the state didn't meet the standard of recklessness, but did meet the standard of negligence, and therefore found him not guilty of the aggravated vehicular homicide, but guilty of the lesser included offense of vehicular homicide. Much like you might get in a murder case where a judge or jury looks at a murder charge and says the state failed to prove that, but the state did prove a lesser offense of manslaughter, and enter a verdict on that basis.
It really sounds like, Ron, that intent was kind of the key factor here, and that cell phone was key to the case. Based on then your years of being a prosecutor in similar cases, were you surprised by the judge's decision?
Frankly, I don't think I was. I didn't know the details of the case other than what was publicly reported. But you always, as a prosecutor, have difficulty meeting in a case like this the higher standard. You can show that they're legally responsible for the crime, but the degree of the crime is where the difference between a felony and a prison sentence or a misdemeanor and a jail sentence is the dividing line. And in those kind of cases, you really have to show that the person is driving fairly recklessly. I use the example of someone going 40 miles an hour in a school zone. That would be reckless. If the person, however, just runs a red light, hits another car and causes somebody's death, they're negligent when they did that, but running the red light is likely not going to rise to the level of recklessness.
Ron, do you feel like it was a smart move by the defense to do a bench trial and no jury because there was so much emotion surrounding this case?
Yeah, absolutely. I think it was the right decision from the defense standpoint, simply because when you have that many injured or dead people, the jury is going to look at the case and try and find a way to render a guilty verdict, whereas the judge is going to parse the legal definitions and parse the evidence before him or her, and then render a verdict based solely on the evidence. So the entrance of either emotion or sympathy is less likely to enter in a bench trial than as a jury trial.
And real quick, Ron, because we only have about 10 seconds left, I got to ask you, the 18-month cap in Ohio for the misdemeanors. A lot of families are really reeling about this because there were 6 people who died. Why is there a cap for that? in terms of
I
prison
think
time?
the legislature, when they enacted it, was to avoid someone who's a petty thief, for example, that's a shoplifter and he goes to 10 different stores and steals, and that could end up in 10 different first-degree misdemeanor sentences. And, 6 months times 10 would be a long time, and they don't want people in prison for misdemeanor crimes. So at least they capped it at a max of 3 on a misdemeanor series of offenses.
Well, Ron O'Brien, former Franklin County prosecutor, we always appreciate your time, your insight, and your expertise. Thank you so much for joining us.
Okay, thank you, Angela.
Thank you. Good to see you. And of course, we do have extensive coverage of today's verdict with our 2 crews in Newark. Tonight at 5, Kevin Landers talked to a woman whose child was on that bus and what this ruling really means to the Tusky Valley community.